We start off, we've got two cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation.
Buckle up, folks. Today's courtroom drama is a tangled web of past convictions, back-to-back burglaries, and a defendant who just couldn't stay out of trouble, even while out on bond. We've got repeat offenses, bond mishaps, and a judge who is clearly done playing games. Our defendant is facing a third-degree felony sentence with no chance of probation, and the timeline is jaw-dropping. How does a man on bond for burglary get caught committing the exact same crime again at the same location just weeks later? Stay with us as the judge peels back layers of missed GPS orders, shady bond amounts, and an accused who may have underestimated the court's patience. This one's about to get intense.
On or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building,
Yeah.
not a habitation, a burglary of a building, which is lesser than a burglary of the habitation. That's no less than 180 days up to 2 years in the state jail. Burglary of habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building. It's like the same building owner. The victim is the same as the previous case.
Probably discount tires. Right?
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes,
Judge, if he's
Two prior state jail felonies on separate.
Next to the third.
makes it a third
So,
degree.
well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than 2 nor more than 10 years confinement in prison. And
Did you catch that? Because of 2 prior state jail felonies, his punishment range skyrockets. He's no longer facing 180 days to 2 years. Now it's 2 to 10 years and no probation. That's right, 0 eligibility for leniency. The legal twist here? This current burglary might be a state jail felony, but under Texas law, it gets treated like a third-degree felony due to prior convictions. This is why history matters in court. Those old charges from 2005 and 2015 just came back with teeth. Do you think that's fair? Should a decade-old weed charge still influence your sentence today? Let us know in the comments.
a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
Your Honor, the state has tendered an offer of 12 months or 1 year in the state jail facility. And
How much time does he have credit, if any? Please. Okay, go ahead.
Mr. Landry's advised that he's refusing that. Is that correct?
Okay,
You don't
That's what you wanna do?
The state's offer.
that's what you want to do?
Speak up.
It's a hard decisions, but it's your life. Right now, we're at a crossroads. It's either going to go that way or this way. Which one?
So, to be clear, one of the things that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases so that they're both dealing with third degree. Sure.
Okay, it wasn't. Yeah,
It wasn't included in the
indicted.
first indictment for some reason. We must have recovered them by the time he alleged to have committed the second offense.
But he has 17 days credit.
Okay, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds? Each.
$5,000?
Each. Be probably 5 each, Your Honor. That's what he seems to.
He's correct.
Okay. When was this bond posted? In 908? I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right,
It's
then
$5,000
he's alleged to have committed the second offense while he was
in
on bond.
September. Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation may have run the initial arraignment may have been 20.
There's a 715 of $5,000 on 7 that he paid on 715. But then there's a warrant for an arrest, a capias, burglary of a building, filed on July 16th. Okay. And the bond was fixed. Who signed this?
He probably
It
got
says the amount of bond fixed by the court in this case is $25,000 here.
That was probably the initial arraignment. He didn't postpone.
Yeah, it was an
And
arraignment.
he got out on accusation after that, and the warrant popped up sometime after he was released on accusation in the bond.
But it's
On the
showing
warrant,
5,000.
was set at 5.
Is that right, Lacey? It's showing 5,000 on this. Okay.
When he was arrested on the.
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
No, the second offense is on or about September 17th of 2024. All of this is July and July.
It's the initial bond he made in 908. Was made on 7/15 of 24,
Yes. Of,
$5,000.
yes. Then what?
And then it looks like. Looks like the bondsman surrendered that bond when he was rearrested. And he made another bond. In this case on 2/10 of 25.
Of how much?
The initial bond was.
No, I'm talking about the new bond.
Should have been 10 if there was an airport.
It wasn't an AFR, so it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new thing.
10 of 25,
What was that bond?
5,000.
Yes. Well. On what day now?
2/10 of 25.
Okay.
That's after the.
Yeah, that indictment had already been
Right.
prepared and has those prior convictions, and then you have that.
Right.
It just slipped. It must have slipped by somebody. See, on this indictment, here's what's, once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand.
And there it is. The judge has had enough. We're not just dealing with charges here, but pattern behavior. The defendant was already facing a burglary charge. Then, while out on bond, allegedly committed the same offense again. Same type, same method. It's like pressing rewind on bad decisions. Now the court's slamming down $100,000 bonds for each case and demanding GPS monitoring. And here's the kicker. Court orders were ignored or changed without explanation. How does that even happen? Internal miscommunication or something more? Either way, the judge is laying down the law hard, and this time, the consequences are sticking. Would you trust this defendant to stay out of trouble again?
But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
I represent the court. I didn't have anything to do.
you didn't. Yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case, and somebody else was changing these.
It was post indictment.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. Once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond. A few months later, you're committing another of the same offense, same type of offense, as though none of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you said.
So what did we witness today? A man with a history of felony convictions finds himself accused of committing another burglary while out on bond for the first. His past offenses elevate the punishment range, wiping away any chance of probation. And the court isn't having it. Between missed GPS orders, bonds that mysteriously dropped from $25K to $5K, and back-to-back crimes, the judge doubled down. $100,000 bond on both charges and strict pretrial monitoring. This isn't just a warning, it's a crackdown. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Justice doesn't rest, and neither do we.